Good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer with Samfiru to Markin LLP. I'm located in Toronto. As you know, we have offices in Ontario, in British Columbia, and Alberta. I've been doing these sessions for quite a while now. We offer these Q&A sessions multiple times every week across our offices. And again, of course, the goal is to ensure that your employment law questions are answered. This is a free opportunity to ask your questions. Everyone is dealing with employment issues. Most people are employed. And so if you have questions about your employment, about how to deal with your employer, about a challenge with your colleagues, if you've been terminated and offered a severance package and you don't know whether it's a good package, if you have experienced changes to your terms of employment, maybe your duties have changed, maybe your employer has said we're going to reduce your hours or reduce your pay. These are all very important topics, and they're the topics that we deal with in these Q&A sessions. So please don't be shy, ask your questions, and we're going to try to get to as many of them as possible today. Before we do delve into those questions, what I like to typically do is start off with an important topic in employment law. And most of the time, these topics are very relevant to all of you. So the topic today is going to be the topic called the duty to inquire. As many of you may know, in Ontario, you have rights under what's called the Human Rights Code. Okay? The Human Rights Code provides you with your rights, your human rights. And many of the issues that we deal with are the employer's failure to accommodate employees. Okay, it's a very common issue if the employee has been faced with discrimination, or if the employee needs certain accommodations in the workplace and the employer doesn't provide those accommodations. These are common human rights issues that I deal with in my employment practice very frequently. A lesser known issue is what's called the duty to inquire. So this is different from then your employer's duty to accommodate you. They actually have a duty to inquire about what they might be witnessing your behavior in the workplace. If your behavior has changed, if let's say your employer is noticing that you're absent more often or you're experiencing more stress, then your employer has to actually inquire about that. And they have to inquire about that before you might even have an opportunity as the employee to seek an accommodation. Okay, so most people might think that if they seek an accommodation, yes, the employer has to abide by that, presuming that you've sought the accommodation properly. However, it goes beyond that one step. Your employer actually has a duty to inquire about the changes that they might witness that are occurring in your behavior. And they can't discipline you. Okay, so this is very important for employees because you are provided with this protection before you can be disciplined. For example, if you're absent very frequently and it's because of a specific reason, maybe childcare obligations, maybe burnout or something like that, then while you might be disciplined for being absent, your employer, if they notice these absences, they have to actually inquire. Maybe there's a good reason for it. It also allows your employer to provide the help that you might need, right? The accommodation that you might need. Maybe you need a later start time. Maybe you need more frequent breaks to deal with the stress that you're experiencing at work. Okay, and this will allow you to be treated fairly and equally among your colleagues. Now, if you feel that your employer is failing in this duty to inquire, as we always say with really everything you're witnessing at the workplace, everything you're experiencing, it's very important to collect evidence, right? And usually this evidence will be in written form. So just keep a record of the changes in your performance, any communications you have with your employer about that. And if, of course, your employer you feel is punishing you as a result of it instead of inquiring about your changes in your behavior, then that is a problem, and you have to keep records of that evidence. Okay, keep records of how your employer might have penalized you in a certain way. And of course, if you're experiencing any of this, you should consult with an employment lawyer. Anyone at my firm, certainly, I would be very willing to help you and to consult with you about if you're experiencing any of these issues. Okay, and of course, if it continues to escalate, then you might be terminated. It could be that you're entitled to a severance package. And on top of that, you would be entitled to human rights compensation for not only the fact that you were terminated, if this all led to a termination, but also the fact that as part of your termination, your human rights were breached. And so you'd be entitled to compensation for that as well. Okay, so it's a big topic. I just wanted to, at the very least, scratch the surface about the duty to inquire. It is something, like I said, that employees know a little bit less about, as opposed to the employer's duty to accommodate you. So now you know. And again, if you are dealing with any of this, please reach out at helpanemploymentlawyer.ca, and we would be happy to arrange a discussion with you about that. All right, now, as promised, let us delve into some questions here. So our first question is on YouTube from Sonia. My employer has been talking about retiring for the last 2 years, but never provided a definitive date. I received a verbal notice today of the upcoming retirement on January 1st, 2025. I will lose my job after 35 years. Do the last 2 years count as notice, which will diminish my entitled severance? Can I still get severance? Okay, great question, Sonia. So severance is really a way of talking about notice of termination. Okay, and that's what Sonia is alluding to here. So if your employer provides you with what's called working notice of termination, they're telling you that your employment will be terminated, and they're being very clear about it. Okay, and in Sonia's case, the employer didn't provide a definitive date. You have to have been provided with a definitive date in order for the notice to count. So if you are provided with a definitive date that your employer is retiring or closing down the business or whatever it might be, then that will count as some of your notice. So let's say you're provided 2 months of notice of that. Then if you're entitled to 10 months of severance, well, you already received 2 months of notice of your termination, so you'd only be entitled to another 8 months of severance, okay, in that example. But again, you have to have been told definitively what the end date is, what the termination date is, and that date can't change. I've dealt with cases where the date kept changing, and that makes it a much more complicated situation, and you may not, you might be entitled to your full severance, and the notice that your employer provided to you would not be sufficient in that case because there was not a definitive date of retirement or of the closing down of the business. All right. So Sonia, I hope that answers your question. And if you have a follow-up, please post it in the chat. Okay. We have a question from Shannon on Facebook. I had some transportation issues at my work, and I offered to come in when able or work from home. Most of my job is computer-based. Both options were turned down. My employer then agreed to a temporary leave of absence. 2 weeks later, they hired somebody full-time permanent for my role. Is this allowed? Okay. So there's a few things going on here. One, if your employment has ended because someone else is in your role, then your employment has been terminated and you're entitled to your full severance pay. Now, what also could be an issue here is the fact it's potentially a human rights issue. If it's really just transportation issues, it's not that you have to get your kid to school on time, for example, and that's why you are having issues coming into work, that would be considered a human rights issue, and your employer has to accommodate that, which we spent a lot of time talking about it at the beginning of this session. But if you're on a leave of absence, your employer agrees to that, and then they take another employee and they fill your role, then presumably if you don't have a role at the organization anymore, then you've been terminated and you're entitled to your full severance pay. It's really as simple as that. In terms of whether your employer has to allow you to work from home, they don't have to allow you to do that. If you haven't been working from home throughout the course of your employment, and now you want to work from home, your employer is not obligated to permit that, unless, of course, that is really one of the only ways, or the only way, that you can be accommodated, right? Again, your employer has a duty to accommodate you for a certain need you might have that's human rights based. So if you have a human rights based need and it requires you to work from home, you might have to provide some medical documentation if that's relevant in that case, and then your employer would have to accommodate that. But if it's just more simple for you to work from home, you don't have to commute as often or as long, then your employer does not have to provide that accommodation to you. However, if you have been working from home and your employer has been fine with that throughout the course of your employment, and now your employer is requiring you to come in, and we were dealing with this a lot after COVID. We're still dealing with cases like this where employees were able to work from home during COVID, maybe even before COVID, and then during COVID, and now the employer is saying you got to come back to work. In some cases, that will be considered a termination. And specifically, it's considered a constructive dismissal, where your employer is not saying you're terminated, and instead what they're doing is changing specific terms of your employment. In this case, you were able to work from home. Now your employer is saying you're not able to work from home. That would be a significant change to the terms of your employment, and it would be considered a termination, and you would be entitled to your full severance pay. Okay, in that case, there is a specific way to deal with constructive termination. So again, if you're facing this kind of thing, then please contact us at help@employmentlawyer.ca, and we'd be happy to assist you. All right, let's move on. I'm happy to see lots of questions here. Okay. We have a question on YouTube from The Chosen One. Great name. The Chosen One says that they got into an argument with a coworker. Both parties were suspended for the rest of the day. They weren't given a return to work date. It's now 4 weeks that they have been off. Is this legal? The employer said there's an investigation going on. Doesn't seem like there was a physical altercation, just words back and forth. Okay, so yes, your employer is allowed to suspend you in order to investigate a certain altercation at work. If they don't provide you with any definitive return to work date at any point in time, then you can consider your employment terminated, and you'd probably be entitled to severance in this case. If you just get into some argument with a coworker, that doesn't mean you can be terminated without any severance pay. So you would be entitled to your severance pay there. It could be, though, that your employer is going to provide you with further information shortly. It might be that they tell you have to come in for a meeting as part of the investigation. It could be that they say the investigation has concluded and you're able to return to work. So lots of options as to what might occur. If you don't receive definitive information for another couple weeks, I would say, then reach out to us, and again, we can figure out what's going on here. And it could be that your employer is letting you go and they're just not advising you of that, which would certainly be a problem, because you have to be informed if you're being terminated. Okay, I hope that answers your question. And if you have any follow-up, The Chosen One, then please post in the chat. Okay, we have a question on YouTube from Shay. I was dismissed from my part-time job last month. When I was hired, I was able to work part-time and I set my availability as such. At the time, I was single and childless. Fast forward to 2022 and I became a first-time parent. I asked for some leniency in my hours and it was granted. This was under one manager. Then a new manager took over and their shifts were taken away. And you were told by your employer you either have to work your old shifts or be fired. Am I owed any severance? Okay. Yes, Shay, you are owed severance pay. If whether you work part-time or not part-time, if you're terminated, you're owed severance pay as a part-time employee or a full-time employee. And again, here, this could also be considered a human rights issue. If you had to work certain shifts and your employer was accommodating that because you became a parent and you needed to work certain hours because of your childcare obligations, then your employer had to have accommodated that, and it sounds like they did initially. And then when a new manager took over, the manager was not accommodating you anymore to work those shifts. So if you don't have shifts anymore, A, you're terminated. B, there's a human rights issue going on here. Definitely worth contacting us about this, and we will help you obtain your severance pay and any compensation that you deserve in this case. I'm going to take a moment here to talk about severance pay a little bit more in general. Again, it's a very relevant topic. It comes up in most of these questions here, so I want to ensure that we address it thoroughly. Severance is calculated based on your age, your length of service, the position you held, your remuneration, how much you were paid is relevant, and generally speaking, how easily can you find a new job given your circumstances. This is how your severance pay is determined. Now, you might have an employment contract that limits your entitlements, your severance entitlements, to a certain amount. Please have us review that contract before you assume that it does in fact limit your entitlements, because many times people think that their employment contract says they only get X, and really they can get much more than X because the employment contract is not valid. And we assist people with that every single day. So very relevant, and ensure that you contact us if you're being offered a new employment contract or you're being told that you're only entitled to a certain amount of severance because of what is written in your employment contract. Now, if you're curious about how much severance you are entitled to, we have a tool that's called a severance pay calculator. Okay, you can find this as part of our Pocket Employment Lawyer at pocketemploymentlawyer.ca, as you see on the screen. It's a free tool. It's anonymous. You can use it whether you've been fired or have not been fired. If you think you might be fired, if your friend has been fired or a family member, tell them to check out this tool, pocketemploymentlawyer.ca. It will ask you very simple questions. And then it will determine how much severance you would be entitled to. And usually people are surprised that they're entitled to much more than they thought. Okay, so feel free to check it out. Again, free and anonymous. After you use the tool, you might want to contact us at help@employmentlawyer.ca. And if in fact you have been terminated, or you presume that you might be terminated soon, we will help you navigate through that, and we will help you obtain the severance that you are entitled to. Okay. Now, with that said, let's dive into another question here from Dominic on YouTube. A new company took over their job site and offered the employees jobs to stay on with the new company. I've been working for a week and haven't signed a contract yet. If I was let go, would I be entitled to full severance? Okay, very good question here. Yes, you would be entitled to full severance. The fact that you have not signed an employment contract does not mean you're not entitled to severance pay. In fact, employees who don't have employment contracts are usually entitled to their full severance pay And employees who do have employment contracts sometimes are not entitled to their full severance pay. So simply put, having an employment contract does not guarantee you severance, and you don't need to have an employment contract in order to get your severance. You are entitled to your severance as a matter of right. Okay, if you're an employee, you are entitled to your severance pay. Doesn't matter whether or not you signed an employment contract. Sometimes, as I mentioned previously, if your employment contract is really well written and it does limit your severance entitlements to a certain amount, then you'd only get that certain amount. Most of the time, employment contracts do not do that properly, and so you're going to be entitled to your full severance pay. Okay, so very good question. It was asked, I answered it, and so everyone, if you have questions similar to that or any question you might have, please post it and I will deal with it. Okay. We have a question from Reg on Facebook. After working 2 cumulative years, I submitted my resignation for a 2-week notice as per my employment agreement. However, my boss terminated my employment immediately after I filed my resignation. My employer even escorted me out of the premises and approached my car to take all the work equipment that I have. Am I owed compensation? Yes, you're going to be owed compensation. If your employment contract says that you have to provide 2 weeks, and that's a very standard amount of time of a resignation notice, right? You have to inform your employer 2 weeks before the date you want to resign that you are going to be resigning. Sometimes your employer doesn't want you to stay that 2 weeks once they know that you want to resign, and there's various reasons for that. It could be that your employer, just doesn't want to have an employee around who they know is leaving because they don't trust you anymore, or they don't want you to convince other employees to leave their employment. There's various reasons why an employer might say that they're waiving your resignation notice and they want you to go right away. However, if they do that, then you are entitled to your pay for that period. Okay, so if you give 2 weeks and they let you go right on that day, you're entitled to at least that 2 weeks that you provided as notice. Okay, great question, and it's a common issue. It really is a common issue where employees want to resign, they do resign, and then the employer waives it. And what happens in that case? Okay, now let's move on to another question here. On YouTube from Noir. I was dismissed from my full-time job. I was under accommodation over 2 years for the permanent injury I had at work. I've been offered 4 weeks in the termination letter. I worked for the employer for over 4 years. Okay, does not sound like it is enough severance. If you have worked there for 4 years, and especially if you suffered a permanent injury, which might impact your ability to reemploy, then you're going to be entitled to more than 4 weeks of pay. Now, I do need to have more information. I need to know your age. I need to know what position you were in, how much money you earned, and I need to review your employment contract because, again, that could be a very relevant factor here in terms of how much severance you're owed. However, I can tell, putting aside the employment contract, even without having your age and your position and the amount that you earned, if you have suffered a permanent injury, you're under accommodation, then they let you go and they only offer you 4 weeks, it's not sufficient. So we will absolutely help you. Contact us at help@employmentlawyer.ca. This is a very, very common issue that we deal with every single day. So we'll help you out. All right, let's move on to question on Facebook from Louisa. I've been with the company for 33 years. They are in the process of obtaining medical and dental benefits for all employees. However, the person preparing benefits was told to exclude me since my husband has a benefit plan at his work and I do not require them. Is this against the law when all other employees are considered for the benefit plan? The good, interesting question. So if you want to have benefits, even though you are covered under your husband's plan, you're entitled to participate in the benefits plan, so long as you can benefit from it. double use of the word benefit. So long as it has value to you to participate in the benefits plan, then you should be able to participate just like all of your other colleagues. You might not actually want to. That's something you have to determine. It could be that your husband's benefits plan is sufficient. That's not really for me to determine for you. But what I could tell you is that you should be able to participate if you want to participate. And of course, that will cost money. Usually there's deductions that's going to be made from your pay if you participate in the benefits plan. So that's something that you should consider as well, okay, when making your determination. But if your employer is giving you an issue with that, please contact us, help@employmentlawyer.ca. We'll arrange a consultation. We'll learn more about what's going on here. You'll provide us with documentation, any email correspondence about this, and we'll provide you with further advice. All right. Another topic I want to discuss is we are noticing a trend that companies are promoting individuals who work in person more than they're promoting employees who work remotely. Now, this doesn't happen across all workplaces. It's just a trend that's been happening. And so there's various reasons why that might happen. It could be that your employer or an employer who's doing this, who's promoting in-person workers as opposed to remote workers, they might feel that the people who come in are more committed to the workplace. There's more growth opportunity for that employee because they come in. There's more collegiality because the employee comes in and they interact with their colleagues and their manager and boss. And the employer might feel that the remote worker is not as committed. Maybe they can just resign. They might resign at any time. They might just go find a job with another employer who allows them to work remotely. So again, it's not about whether this is true or not true. The issue is more about that this is a trend. Again, not across all workplaces, but it is something that we're noticing. Now, this does have some implications. Again, if you are working remotely, not just because you're permitted to, but you have to, it could be an accommodation that your employer is providing you. I like to use the example of childcare. If you have childcare obligations, because that's something that's very relevant for many Canadians, and your employer, as a result, is allowing you to work from home full-time or part-time. And as a result, you're noticing a real trend that you are not being promoted. Your other colleagues, perhaps, who work remotely are not being promoted, as opposed to people who are working at the same level as you. And they are being promoted because they work in person. So that could be a human rights issue. So each case is different. The circumstances matter, but it is a trend that we've noticed. So we want to convey that to all of you out there. Maybe it applies to you. And if it does, we can arrange a consultation and we can see whether, in fact, there is a legal issue with the fact that you have not been promoted like your colleague has. Okay, we have time for one more question. We got one in on YouTube from Benjamin. Benjamin was suspended without reason for 3 days, never given a reason, asked to return to work, but lowered their status, kept the same pay. Okay, so this could be a constructive dismissal, again, where you're not being terminated, but your employment terms are changing. Your employer is saying, without your consent, Benjamin, we're going to change some of the terms of your employment. May not be your pay. It could just be your duties, could be the person that you report to is different, maybe your hours. These are all legitimate changes to your employment. And if there are significant changes, then you do have recourse. You can pursue your severance pay. Again, it is considered a termination. So Benjamin, if you want to hear more about that, arrange a consultation and we'll discuss more thoroughly. Again, help@employmentlawyer.ca. We're done for today. It was great being with you. We had many questions, many important topics that we explored, and we have another employment law question and answer session tomorrow with my colleague, Dan, at 10:30 a.m. Pacific time. It was great being with you. Take care until next time.